Hello, my name is Devi Aprianti from Parallel Class 2022. Allow me to read the passage about the role of law in international trade. There is a considerable diversity of law throughout the world. We have seen that there are various legal systems. The rules of contract in the common law countries are not the same as those in the Roman Germanic system. But even within one system or family of law, the rules applied in various states are not identical. Thus, the principles of contract law developed in the United States are similar to, but not identical to, those applied in Australia. The diversity of law is not conducive to international trade. It crosses national boundaries and involves more than one country. In the case of international sale of goods, the buyer may be the resident in one country and the seller in another. In this circumstance, it may be asked whether the arrangement between the parties is governed by the law of the buyer state or the law of the seller state. How are these problems to be resolved? One might commence by inquiring whether an international transaction must be governed by a particular system of law or whether it can exist independently by rules of law. The traditional view adopted in England and Australia is in the affirmative and holds that every contract is governed by a national law. However, there are some legislative qualifications to the principle. Under the Uniform Commercial Arbitration legislation enacted in all states and territories of Australia, the parties to an arbitration may empower the arbitrator to act as amiable compositor. This frees arbitrator from having to decide according to the rule of law. An extract from Mustill and Boyd, The Law and Practice of Commercial Arbitration in England, examines amiable composition from a rather skeptical English viewpoint. But leaving aside this particular situation, we can accept the general proposition that every contractual arrangement must be governed by rule of law. Thank you for watching. Have a nice day.